With the doctrine of precedent out of the way, the next thing we want to have a look at is statutory interpretation. So while it might seem a very simple thing to do to read and interpret a statute, at times it can actually be quite complex. And that's because sometimes statutes aren't written as clearly as what you might think they would be. So let's hop into it and see some of the problems and also how the law's gone about addressing these problems. We're going to do a little bit of history to get us to a point to understand how judges use several different rules at the same time at the moment, and then talk about the predominant way judges approach the problem. So as I mentioned, we're going to look at why we have statutory interpretation, and then we're going to go through three key approaches that are used. The kind of old approach of the common law approach, which evolved into becoming the contextual approach, into the statutory or purposive approach, which uses an act of parliament to help us interpret other acts of parliament. And then we're going to tie it all together, thinking about how the rules tend to be implemented and how they work. So here's a couple of problems. Imagine Chris is going to cross the road at a pedestrian crossing, the signal's flashing don't walk, and Chris decides to skip across the road. So are they going to be found guilty because, they're not walking, they're skipping? Similarly, imagine there's a sign at a bar outside the dancing area at a discotheque says by law audience members are not allowed to bring glasses onto the dance floor. If you're far-sighted, how will you be able to judge the suitability of your dance partner? I mean, clearly there's a difference between, does this mean spectacles or does it mean a kind of container? Okay. So we can see real-world examples such as Carr's case that we'll talk about when we do the particular lecture. So the key thing here is a piece of legislation may say one thing and then people try and use wordplay to get around it, as in the first example, or in the second example, it could honestly be interpreted multiple ways. How do we solve these problems? The way they're solved is that judges use rules of interpretation, and we're going to deal with these three rules: common law rules, the contextual approach, and the purposive approach. So the first approach that judges used came about before there was an Act of Parliament to guide us. So the judges developed their own rules, these common law rules. Now the principal rule that judges go back to, if they can, is the literal rule, which says, look, if the text literally makes sense with the words and phrases given their ordinary and natural meanings, then that's the approach you should take. So an example of that is our case Fisher and Bell. In Fisher and Bell, there was a statute that said anyone who sells, lends, or gives a flick knife to any other person commits an offence. Well, Bell, in this case, had a flick knife with a price tag on it in the window of his shop and was charged with an offence. But the court found he wasn't guilty. Why not? Because we'll learn in contract that putting something on display in a shop is an invitation to treat. It's not even an offer. So he wasn't selling it, lending it, or giving it literally. He merely had it on display. So literally, he hadn't done what the Act said he would have to do to commit an offence. Okay, that's the literal reading of that particular piece of legislation. Now, sometimes if you read a piece of legislation literally, you can end up with an absurd result. Okay, and so what happened in these cases is judges would modify the literal meaning to avoid the absurdity. That's called the golden rule. A good example of the golden rule is the case of Lee and Knapp. Now in Lee and Knapp, part of the Road Traffic Act in the UK said that if in any case owing to the presence of a motor vehicle on the road an accident occurs whereby damage is caused to a vehicle other than that motor vehicle, so if you have an accident and it damages the other car, the driver of the motor car shall stop. Okay, so if you hit someone and cause damage to the car, you have to stop. Knapp was charged with contravening that section because he left the scene of an accident. He argued that he did stop. He stopped momentarily for an instant when he collided with the other vehicle and then took off. The court rejected that literal interpretation and decided the word stop should be interpreted as requiring the driver to stop at the scene of the accident for long enough to exchange contact and other necessary details. Okay? So it's absurd to think that stop under that section of the Act meant, oh, well, when you stop in the accident, you can just immediately go on afterwards. Okay? It was an absurd result. So they interpret it to mean stop to exchange details, long enough to exchange details if the other person wanted to. The third rule then extends this kind of idea of an absurdity even further to the mischief rule. And it says, look, if there's any ambiguity in a legal text, we should consider the problem or the mischief the legal text was intended to address. The mischief rule. So Smith and Hughes is an example of the mischief rule, where under the Street Offences Act, it was a crime for prostitutes to loiter or solicit in the street for the purposes of prostitution. So, okay, so just again, they're not allowed to solicit in the street. However, the defendants here weren't in the street. They were calling out to people in the street from balconies. They claim they weren't guilty as they weren't in the street. Now, literally, they weren't in the street, but the court in this case applied the mischief rule and said they were guilty because the intention of the act was to stop people being harassed and solicited, and that was still occurring. So because they focused on the problem, the mischief, they interpreted what in the street would mean to stop that mischief. And so soliciting from the balconies above the street was considered within that definition. What we can see is an evolution of the way that the courts have approached statutory interpretation, moving from the literal rule to more trying to understand what the point of the legislation was. That led to the approach to interpretation becoming contextual. So judges would consider the context of the statute. Think about the following provision. All building personnel shall not go within 5 metres of a crane without foreman approval. Workers are worried they're breaking the law when a waterfowl on the site chases them for food. Okay, so what do we mean by crane? Okay. So the courts these days are going to look at the context of the use of the word crane. They're going to look at the immediate context, the words around the uncertainty. So we can see foreman approval, building site, building personnel. If there are two meanings of crane, we need to interpret it in light of the immediate words around it. We've got to look at the act as a whole. So if this was obviously, in a workplace safety or a construction act, we'd be going, well, what kind of crane is it more likely? We'd have to see if any other legislation looks at it, the prior law, and the mischief. Why have they got this section in the Act? That is more than likely. I think it's almost certain that crane will be interpreted to be the machine, not the bird. Okay, so the context becomes important. In Australia, this was made much easier by a series of acts in all of our jurisdiction, called various things, but in the Commonwealth and in Queensland, they're the Acts Interpretation Act. Now, they were implemented at two different times, I think 1901 from the Commonwealth and 1954 from Queensland. So what that did was it was a piece of legislation, which of course means judges have to use it, that told judges how to interpret unclear legislation. And it said you should look at the purpose of the act that you're trying to interpret. In fact, let's have a look at what Section 15AA of the Commonwealth legislation says. So that section says, when you're interpreting a provision of an act, the interpretation that would best achieve the purpose or the objective or the object of the act, whether or not that purpose or object is expressly stated. Okay, so that means now you can look at other things. So it doesn't have to be stated in the act what the object is. You can look at what might that purpose or object be. So in interpreting a provision, the interpretation that would best achieve the purpose of the act is to be preferred to each other interpretation. Okay, so what interpretation wins? The one that best achieves the purpose of the act. That's why we have the purposive approach. In practice, that means if you're reading the text literally and that doesn't reveal the meaning of the text, you should refer to the apparent purpose. Thus, a legal text should be interpreted so as to promote the purpose of the object. Sometimes the act contains an object clause, but the courts are also willing to admit other material, extrinsic material, such as second reading speeches from the minister and explanatory memoranda where there's ambiguity. Now, they do that not to question the ordinary meaning of the statute, but in order to understand the statute better. So all of these rules come together when a court goes about interpretation. And here's an extract of some insight given by Michael Kirby, who was a retired judge from the High Court of Australia, probably one of Australia's most preeminent judges. And what he said is that the High Court, remember the highest court which sets precedent, has unanimously endorsed principles for using statutory interpretation, including where the relevant law is stated in legislation, then the starting point is the text of the legislation, like the literal rule. However, the overall object of statutory construction is to give effect to the purpose of Parliament as expressed in the text. Okay, so we've got to look at the purpose. In deriving the meaning of the text, words should not be considered in isolation, but rather to examine the sentence or paragraph and identify the meaning in the context. Okay, so we've got to look at what's actually written literally. We've got to look at the purpose it's being used for and the context of the section. Oh, okay. Well, how does that come together? Here's a little bit of a decision tree which might help us. So when we have a piece of legislation, we can say, look, is there a clear single meaning of the provision? Right? Is it clear, crystal clear what it means? Yes? Okay, excellent. Does the context suggest a different meaning? No, the context suggests that meaning. Okay. Does the purpose of the act suggest a different meaning? No. Okay then, use the literal approach. Now, if there was a single clear meaning and the context suggested a different meaning, does the context offer a single clear meaning? If it doesn't, we go to the purposive approach. Can we base it on the purpose? If the context does offer a clear single meaning, does the purpose suggest a different meaning? No. Okay, so here we're saying there's no conflict between the purpose and context. If so, we use the contextual approach. If there is a conflict, if the purpose suggests a different meaning, we use the purposive approach. Okay. So what you can see if you go through this diagram, and I'll leave you to think about it in detail, is that we kind of use the entry-level rule, the literal rule, provided there's no other conflict. Then we move to the context rule. Can we determine it just literally and by context? And if there's no clash with the purpose of the act, okay, that's what we can use. But if we get any conflict with the purpose, then we have to use the purposive approach. Why? Because Section 15A in the Commonwealth Act, and I think it's 14A in the Queensland Act, says that is the one to be preferred. So we always have to end up preferring the purposive approach if there's a conflict. So we understand that it's highly unlikely you're ever going to have to read and interpret legislation as a judge or even as a lawyer. However, by understanding how lawyers approach this and how lawyers think about legal text, it helps you better understand and interpret the advice that you get. It's also a great way of improving your analysis and logical thinking skills. So I'll leave you to have a look at this particular slide and some of the advantages that come with understanding a little bit about statutory interpretation.